Warm welcome, first of all, from BDB Pitmans to this, the first in our series of talks on the law post-Brexit. Interesting times, both obviously practically for lawyers and for clients, and of course constitutionally as well. And we're pleased to be giving these seminars, which will hopefully shed light where light needs to be shed on some of the more interesting and perhaps complicated areas of the new law. Normal sort of standard format, please. If you've got any questions, do put them through to us on the Q&A button at the bottom of the screen, and we will endeavour to answer them probably at the end. But if something comes in that's of importance, then we'll try and answer it on the hoof. My name's David Mundy. I'm a partner with the public law section of the firm, and I'm joined by Aaron Nelson, who many of you may know from his expert blog on the whole question of Brexit, and we're delighted to be talking to you this morning. There are some other seminars coming up later on in the year on the whole question of the law post-Brexit. In particular, the next one I think is on the question of public procurement and state aid in a couple of weeks' time. There's another on data protection and another on immigration, and we'd be delighted if you join us for those seminars in due course. But the purpose of this seminar is to provide a practical understanding of a new concept, retained EU law. It's a new concept indeed in our law, the law of the UK. And it's based on three really important statutes, all of which have constitutional significance. The first is the European Union Withdrawal Act of 2018, which we'll refer to as EUA, EUWA. Then there's the European Union Withdrawal Agreement Act of 2020. And then finally, the European Union Future Relationship Act of 2020. Now, there's some technical law here, but we're trying to keep it relatively high level so that we can get as much information across as we possibly can. Perhaps the key to understanding the topic, though, is to put it into context. And I'm going to ask Aaron to lead off, putting the whole subject into the context of what has happened over the last few years. So over to you, Aaron.
Thanks very much, David, and welcome everybody from me. If I could have the first slide, please. So Brexit, let's start with a quick reminder about how we got here. Prior to Brexit, the UK was an EU member state, and as a condition of that membership, the UK was required to give effect to EU law in the UK, and it achieved this through the European Communities Act 1972, which I imagine most of us will be quite familiar with. And that provided that EU regulations had direct effect in UK law. And it also conferred a delegated power, section 2.2, by which EU directives and other pieces of EU legislation would be transposed into UK law through domestic regulations. So in short, EU law had effect in the UK through that provision, section 2 of the European Communities Act. And this is sometimes referred to as a conduit pipe through which EU law flowed into the UK. Now, in the Brexit referendum, the UK decided to leave the EU, and the UK then served the Article 50 notice we heard so much about at the time under the Treaty of the Functioning of the European Union. And that meant that the UK would leave the EU as a matter of international relations. In the domestic sphere, mirroring that, Parliament passed the European Union Withdrawal Act 2018, and section 1 of that repealed the European Communities Act on exit day. That was subsequently amended, but as made, it was exit day. That meant that the conduit pipe tap was turned off, or would be turned off when that section had effect, and that would create a black hole in the UK statute book. You might remember that phrase being used, caused by the sudden removal of all that EU law. And to prevent that black hole, EUA contained provisions to onshore existing EU law so that the EU law became domestic law. Now, doing this, I think it's important to remember, was the UK's choice. There wasn't anything obliging it to onshore EU law. It could have adopted a different remedy to the black hole, such as passing a whole tranche of primary legislation to plug all the gaps, but was considered a better idea to transpose the EU law with which we had all been familiar. And David will explain more in his section of the talk in a few minutes how EUFRA does that in, EUA does that in practice. The next international development, I suppose, was the conclusion of the Withdrawal Agreement in October 2019, following a very tumultuous year in Parliament, which set out the terms of the UK's departure from the EU. So that was the Withdrawal Agreement concluded by Boris Johnson, after he had replaced Theresa May as Tory leader and Prime Minister. And his deal removed the backstop from the protocol on Ireland, Northern Ireland, in favour of the continued regulatory alignment that's now in place, and provided for Northern Ireland being in its sort of unique customs territory position. We then had the December 19 general election and the Conservative Party's victory, with a larger majority in the Commons, and that paved the way for the approval and ratification and implementation of that withdrawal agreement through the Withdrawal Agreement Act, which had been unsuccessfully introduced before the general election, but was then reintroduced afterwards in a slightly modified form. That primarily provided for the continued application of EU law during the agreed transition or implementation period, and that gave domestic effect to the provisions of the withdrawal agreement, and I will look at that in a later section of this talk. And then the third significant international development was the conclusion of the Trade and Cooperation Agreement, which at the end of December 2020, and that had its domestic mirror in the EU Future Relationship Act, passed at the end of December in very quick time, in time for the end of the implementation period. So, as David's already said, EU law post-Brexit is primarily delivered through these three pieces of legislation. That's the mechanism by which that new concept comes into domestic being. And we're going to look at each of those in this talk. So next slide, please. So I'll start off by giving a brief introduction to EUA. It can be thought of, as I said, as the domestic equivalent of Article 50. So it's the means by which, in UK law, the UK's membership of the EU comes to an end, and it does that by repealing the European Communities Act. The repeal of the ECA made a drastic change to UK law because it removes the basis on which almost all EU law has effect in UK domestic law, and that disapplies direct EU law from the UK as a whole. So 12,000 EU regulations. It removes the legal basis for secondary legislation made under it to implement things like directives. And it means that the domestic courts no longer have legal authority or obligation to recognise or give effect to EU law. But primary legislation made to give effect to the UK's EU obligations, so Acts of Parliament, that wasn't affected by EUA. Next slide, please. So the remainder of EUA then deals with the consequences of the repeal of the European Communities Act by Section 1. Effectively, it's sort of giant sticking plaster to make sure everything still works. It contains saving provisions which retain certain types of EU law, but not all of them. David will explain in more detail, but basically directives aren't retained. But it also onshores EU law derived principles like proportionality, and it converts those into domestic law, preserving them, despite the fact that the UK is no longer a EU member, and the European Communities Act has been repealed. So EUA can be thought of as a sticking plaster, as I said, as a new conduit pipe, or as a toolkit for adjusting and amending retained EU law once it's been transposed. And the objective of all this was to ensure that the black hole didn't appear, that the UK statute book continued to operate as closely as possible, and to minimize differences and provide legal certainty. Now, one important point to remember is that EULA, at the date it was passed, was fit for a no-deal scenario. The text of the legislation was agnostic as to whether there was a withdrawal agreement or an agreement on a future relationship between the UK and the EU, and what the provisions of those agreements would be. And because of developments that happened later, you would need it to be modified as developments occurred, to sort of keep pace with those developments. But as passed, it provided legal certainty in the absence of a deal. So David's now going to take over and talk about how EULA functions in practice, kicking off with an explanation of how EU rights and general principles have been preserved and transposed into domestic law. So over to David.
Thanks, Aaron. Next slide. That's great. Okay, so change in tone. We're now going to be, if we can, turning our minds to the whole question of what actually is retained EU law, what it means. But first of all, we need to remember that EU law itself developed in its own particular way. So this is the EU law that is now becoming incorporated, has become incorporated into our statute book. But that law became, as I say, developed in its own way, and it was influenced, if you think about it, by the legislation and the different approaches of the different member states, of which we were just one, and of course by the European Court of Justice. So interpreting retained EU law needs to bear that in mind, as long as it remains on our statute book, that is. And I think note in particular, please, that general principles of EU law, which I'm going to talk about in just one second, are important in two main ways. They're important as aids to interpretation of EU law, and indeed as the basis for some claims, for some legal claims, where those principles have been breached. But they're there generally to give coherence to the EU legal order that of course still exists, but from which we have excluded ourselves. So turning to those general principles of EU retained law, again, just try and think about it as being now effectively part of our statute book, part of our historic legislation, although it had an EU origin. So EULA specifically retains those general principles of EU law, but note that they can't be used as the basis of a claim after the end of the transition period. Those retained general principles continue to apply to the interpretation of retained EU law. So those principles that were alive and kicking certainly when we were part of the European Union, and indeed formed EU law itself and the way in which we gave effect to it, they still exist in relation to the saved EU law that's now, as I say, incorporated into our statute book. So those general principles, just by way of an example, include the idea of proportionality. All these are European law concepts that in effect have become part of our toolkit, though we haven't really noticed it, I think. So proportionality, that the action should be in keeping with the legislative intent. You don't do more than is proportionate to achieve your intended aim by the legislation. There's a respect for fundamental rights, and I'm going to deal with that in a little bit more detail shortly. The concept of equal treatment is fundamentally important, so that unless it's otherwise objectively justified, equal treatment is a fundamental principle, and obviously that makes sense when you're trying to, in effect, treat all the various member states and all their citizens in the same way. Legal certainty is another part of that equation, really. So we call it probably, under English lawyers would call it legitimate expectation these days. But the whole idea is that all citizens across the European Union could have certainty about the way in which legislation should commonly apply to them. And again, the third leg of that is the EU concept of effectiveness. that really means that there should always be a remedy available, that the member states, in giving effect to European law, domestically make available remedies to individual citizens. So those general principles apply when we look back and try to understand, if we need to, the retained European law that's part of our statute book. Moving on to the next slide, please. I mentioned just now the concept of fundamental rights. And again, that's an important sort of bedrock or theme that runs through retained EU law. Those fundamental rights remain relevant after IP completion day. So looking back again, the way in which that legislation, that law, that corpus of law works is with a fundamental respect for those human rights that actually in sort of European parliaments are called fundamental rights. But those rights can't be used to disapply or quash domestic legislation going forward. There's specific provision in relation to that. Note in particular that EUA specifically disapplied the Charter of Fundamental Rights, which codified those rights, sort of effectively human rights, in European law. So the Charter became part of European law effectively at the end of the Lisbon Summit, and all European law needed to be understood and read with reference to that, to the Charter rights that were so protected. We ourselves have now specifically disapplied that Charter by our departure from the European Union, and it is no longer part of EU retained law going forward. So what's left, one might ask the question, what is left is retained EU law, the element of those charter rights, those fundamental rights that sort of sit now incorporated in the historic EU law that now sits in our statute book. And of course, we still have the Human Rights Act 1998 as domestic legislation to protect those rights. But although they're rights sort of actually under a different sort of umbrella, under the Convention on Human Rights, as opposed to the Charter rights that the European Union particularly took under its wing. So it begs a question, has there been an interference or a diminishing of rights overall, those human rights that were originally, and up until we left the Union, protected all citizens in the United Kingdom? It seems to me that the answer to that is probably yes. I think the best example of that is that the UK courts are now no longer able to strike down legislation that's non-compliant with breaches of EU law as interpreted with reference to the Charter. So there are examples of cases where, as a result of the incorporation of the Charter in effect our law, our senior courts actually struck down domestic legislation made by the Westminster Parliament because it was in breach of those fundamental rights protected by EU law. Now that we've left and now that disapplication is in place, there is in effect no longer a court of appeal, if I can call it that, in the form of the European Court of Justice. So previously that jurisdiction was available and is now no longer available to enforce or to try to enforce the protection of your own individual rights. So moving on to the next slide. These are the important elements, please, to try to understand within the context of those two fundamental underlying principles, the principle of EU principles themselves and the principle of fundamental rights. So if we now look at what actually retained EU law comprises, it comes, as Aaron's mentioned, from three main sources. Very quickly, they come from what's called EU-derived domestic legislation. Now that's legislation that we have given effect to in the United Kingdom to meet our obligations under the treaty. There's direct EU legislation. That's legislation or law that came into effect as a direct effect of Section 2.1 of the European Communities Act 1972. And then there are directly effective rights. And all these three are to be interpreted in accordance with retained EU case law, and indeed, as I've already mentioned, retained general principles. So looking at each of those in a little bit more detail, we can turn to the next slide. EU-derived domestic legislation. So as I mentioned, I think the best way to look at this is that this is legislation that required some form of specific legislative effort to put it onto our own statute book. The obvious examples are primary legislation, acts of parliament, or indeed secondary legislation, normally in the form of regulations that were made under the enabling power of Section 2.2 of the European Communities Act 1972 to give effect to our EU law obligations, normally in the form of directives. So a directive was passed by the European legislative machinery, and we were obliged to give effect to it, either by legislation or by regulation. And some examples of that, for example, of the VAT legislation, the Data Protection Act 2018, and indeed example of a set of regulations, the Public Contracts Regulations 2015. But as I say, the key point is that we had to give, it required legislative effort to give effect to it, to put it onto our statute book, in contrast to the next class that we'll come on to in a moment. Now that EU-derived domestic legislation retains domestic status on or after completion, IP completion day. So it is part of our statute book going forward from the beginning of this year. There are provisions, there are enabling powers in EUA to modify it, to correct deficiencies or failures in that legislation, i.e. to make it make sense on our statute book. And as Aaron's already mentioned, important to note that directives themselves are not retained EU law. The directives now are parked. It's the effect, the way in which we gave effect to those directives that are captured in retained EU law. So moving on to the next slide, if we can think about the next class, this is direct EU legislation. No legislative effort required here because all the hard work is done for us by, or was done for us by Section 2.1 of the European Communities Act 1972. And it did that by making that legislation directly effective in the United Kingdom. So for example, EU regulations such as the Data Protection Regulation had direct effect in our legislation without any need for further implementing measures. Now that direct EU legislation is also part of retained EU law and cemented into our statute book. It's been rebadged, and it's important just to quickly pass note of those badges. So there is now direct principal EU legislation. So they are EU regulations, important things, in other words, that are sitting on our statute book. And then there is direct minor EU legislation. In effect, that's everything else. That's decisions of the EU institutions and tertiary legislation, minor legislation passed by the European institutions as now sitting in our statute book. And why is that important? It's important because principal legislation may only be modified by primary legislation in the United Kingdom. So it will require an act of parliament to amend principal legislation unless there is specific enabling powers to amend it in the primary act. Minor legislation can be amended by secondary legislation. So it's just important to sort of note that distinction in relation to this particular class of captured retained EU law. Moving on to the next slide. The third head that's important to have in mind as the one of the elements of EU law that's now retained EU law are what are called, badged indeed in the statute as directly effective rights. I think one can think about this as effectively a sort of sweeper provision, although there are some overlaps with rights under directives. But domestic law rights derived from EU law, including treaty rights that were in effect again, part of our law as a result of Section 2.1 of the ECA 1972. So just to bear in mind that this is we're not talking about what was a regulation, or what was i.e. directly effective, or what was to be implemented in the United Kingdom, such as a directive. What we're talking about is the other rights that came across as a result of Section 2.1, and they included specific treaty rights that are set out in the treaty and in no other form of legislation. And EUA says that those rights, powers, liabilities, obligations, restrictions, remedies, and procedures recognized under Section 2.1 continue to be recognized and available in domestic law, and to be enforced, allowed, and followed. So as I say, it's effectively a sort of sweeper provision. It doesn't apply to rights arising under a directive not recognized by the European Court of Justice or the domestic courts pre-IP completion day. So in circumstances where you had have a directive, for example, that was not implemented in the UK, but nonetheless had rights that could be interpreted from it because they met various tests of clarity, unless they were actually recognized by the European Court of Justice or by the domestic courts pre-IP completion day, then they do not form part of retained EU law. So there's an element of sort of lack of clarity. It's complicated for a start, but there's an element perhaps of a lack of clarity in precisely what directly effective rights are protected now as a form of retained EU law. And I think probably in terms of a class that's ripe for potential litigation, this particular class, where you, for example, have a claimant seeking to argue that a specific treaty right accrued to him in the past and still exists, and that he can found a claim upon it, that is going to be a potential source of litigation, in my view. Moving on, you remember that all these different three boxes, if you like, of legislation that have now become retained EU law are to be interpreted in accordance with retained EU case law. So how do we seek to understand what that law really means that we've retained? We have to rely on the EU case law that was relevant at the time. So where courts are called upon to interpret EU retained case law, fundamental principle is, I think this is the most important thing just to sort of have in one's mind, that pre-exit decisions of the European Court of Justice, so that's the most senior European court, or the senior European court, so pre-exit decisions of that senior court bind the UK courts when interpreting retained EU law, but post-exit decisions do not. So that's the sort of perhaps it makes sense to when one considers the whole issue of sovereignty, but that is the sort of general position to have in mind. But note that EUA particularly made clear or legislated for the fact that the Supreme Court, the Court of Appeal now, and the High Court are not bound by retained EU case law, i.e. that law that was became part of case law before exit day. So our senior courts are not bound by it. However, when they depart from retained EU case law, those senior courts must apply the same test as if departing from their own case law. And if one thinks about the position of the Supreme Court, for example, the Supreme Court quite rarely, very rarely, in fact, departs from its own case law. There has to be a specific distinguishing fact in the case that that allows it to go away from its previous decisions. So if you consider that that's the sort of test that it must apply in relation to looking at retained EU law, case law, then it shows that a good deal of importance and deference is given to the EU court in those circumstances. Noting also that principles and decisions may be modified, and indeed are modified, by the Act itself. So some of those provisions are actually automatically or have already been tinkered with by EUA, and may indeed, and some have already by new enactments, be modified from time to time by the Westminster Parliament, of course. Noting also that UK courts can't refer a matter to the ECJ, as used to be the case, after IP completion day, unless specifically provided for by the withdrawal agreement. And indeed, the withdrawal agreement, which Aaron will come to talk about in more detail, specifically makes it clear that references in relation to, for example, citizens' rights can be made up to a period of 8 years following our departure, end of IP day. And then finally, the final piece of information to have on board is that the European concepts of a purposive approach and an interpretation of law within the limits of EU competence, those fundamental principles are again to be maintained by the UK courts in respect of EU retained law. So when a UK court is asked to look back and consider the retained case law, it has to have regard to the overriding approach of the European Court of Justice, which was to have a purposive approach, so that in effect it means what is intended to mean, but the interpretation is also to take place within the distinct limits of EU competence, bearing in mind the sort of the rights of individual member states to make their own, for their own courts to make their own decisions. So that deals with the question of how we are to look at retained EU case law, how the courts are to look at retained EU case law in issues that arise now and going forward. So moving on to the next slide, perhaps a good question to ask is therefore, what does retained EU law leave out? What is omitted? I've mentioned already the fact that the EU Charter of Fundamental Rights is specifically disapplied by EUA. Under the withdrawal agreement, it is made absolutely clear, if it was not clear enough already, that EU law supremacy is no more, the sovereignty is reinstated. And there is specific provision made for the Frankovich principle to be disapplied. Now, that was the principle developed by the European courts, that if a member state had failed or had failed properly to implement, for example, a directive, that there was a right to damages available to a party that was disadvantaged by that fact. But Frankovich is specifically got rid of by one of the provisions of EUA. And then just finally from me, in looking at modifying EU law, there are powers included, as we've mentioned already, to deal with deficiencies arising from withdrawal. So for example, if I give the example of the Public Contracts Regulations 2015, you'll recall that's one of the types of legislation that we gave, there was legislative effort required, regulations indeed, to give effect to a series of EU directives. That's retained EU law. But so the question then arises, if you think about those regulations, they made reference to the European Commission, they made reference to other member states, and they made reference to directives in various respects. Now, a separate piece of legislation, a set of regulations called the exit regulations, has modified those set of regulations, and therefore all those sorts of, if you like, nonsensical references have been removed by the exit regulations to make the PCRs, the Public Contract Regs 2015, work independently of any European reference. And to note also that there are corresponding powers for devolved authorities to modify EU law insofar as it is within the competence of those devolved authorities to do so. And recognizing that there are obligations placed on the devolved authorities by EU law that need to be are retained but need to be modified in some way, but within that specific constitutional safeguard of within their competence. So I think it's now back to Aaron to give some more context on the next important piece of legislation.
Thanks very much, David. So, black hole thoroughly plugged. with the onshoring, as David's explained, of all those various different types of EU law now transposed through EUA into domestic law. But the clock didn't stop. The political discussions continued, and we had the Withdrawal Agreement and its domestic equivalent, the EU Withdrawal Agreement Act 2020, now introduced by the government, as I said, immediately after the 2019 general election victory, and receiving royal assent in late January 2020. The Withdrawal Agreement gave effect to, the Withdrawal Agreement Act gave effect to the Withdrawal Agreement in 6 ways, and I've listed them there. Firstly, it amended EUA, which David's been talking about, to make provision for the existence of the transition or implementation period which had been agreed, because EUA referred throughout to exit day, and exit day was no longer in effect practical exit day. It had to be the end of the transition or implementation period. So the Withdrawal Agreement Act needed to do that. It ratified the withdrawal agreement and cancelled the specific ratification requirements which Parliament had required be included in EUA. You might remember the parliamentary debates about those and the meaningful votes and all this for business, swept away by the Withdrawal Agreement Act. Third, it gave effect to certain, gave domestic effect to certain provisions of the Withdrawal Agreement. Fourthly, give domestic effect to Withdrawal Agreement provisions re citizens' rights in particular. It made provision in respect of the Withdrawal Agreement financial settlement, and it dealt with the implications of the Withdrawal Agreement for the devolved institutions, largely by mirroring those corrective provisions which David's just referred to as were in EUA. Before I'll take a look at some of those 1 to 6 in a little more detail, 2 specific clauses to mention. The first is just in passing. David mentioned that in terms of retained EU case law, EUA provided that the Supreme Court, and then he said, and now the Court of Appeal, etc., not bound. It was the Withdrawal Agreement Act which introduced the power to enable the government to change which courts were bound, and that was done through an SI called the European Union Withdrawal Act 2018 Relevant Court Retained EU Case Law Regulations 2020, and that added the additional courts, basically the Court of Appeal, High Court and the equivalents across the UK, and said that they could depart from retained EU case law using the same test as had previously been set out under EUA as applied to the Supreme Court, as David explained. The second specific provision is the slightly odd one, section 38, which is a clause specifically about parliamentary sovereignty, sort of states in bold terms that the United Kingdom Parliament is sovereign. It's not really very clear to me what the practical effect of this clause is, because Parliament in sort of standard constitutional doctrine is sovereign, and so can make and unmake its own laws and bind its hands and then unbind them again. But it's just worth noting, I think it probably was of political reasons why it was included, as opposed to any particular practical consequence. Slide, please. So the first element that of the Withdrawal Agreement that the Withdrawal Agreement Act needed to deal with was the existence of the transition or implementation period. The Withdrawal Agreement had provided that the UK would cease to be a member state, but would continue to be treated as a member state under union law during the transition or implementation period, and any changes to EU law would automatically apply to the UK unless provided otherwise until the end of that period. And the Withdrawal Agreement Act made changes to give effect to that. Now, the reason why we've got transition period and implementation period is the government didn't like transition period, so used implementation period, and we've got sort of slight battle of the terms. But Of course, the Withdrawal Agreement Act could just have moved exit day to the 31st of December 2020, but that wasn't politically acceptable. So it's got a convoluted mechanism giving effect to the European Communities Act during the transition period, despite its repeal. And it does this by updating the definition of EU treaties in the European Communities Act to include the withdrawal agreement itself. So during the transition period, the UK was subject to EU law because of the withdrawal agreement, not because it was a member state, because it had ceased to be one. And as I said, changes to EU law during that period were tracked. Now, transposition of retained EU law into domestic law under EULA was also postponed until the end of the implementation period, necessary consequence of the fact EU law continued to apply as a consequence of the withdrawal agreement. And Section 41 of the Withdrawal Agreement Act provides that any references to something happening on or before or after exit day in any regulations which had been made for correcting purposes under EULA were also to be read as if the reference was to the end of the implementation period. So there's just a general rolling everything forward until the later date. Under the withdrawal agreement, the UK was also bound by international agreements concluded by the EU prior to exit day. Again, this idea of rolling forward, although not any entered into by the EU during the transition or implementation period. And the Withdrawal Agreement Act implemented that by adding a new subsection to EUA, taking a snapshot of the applicable treaties at exit day and saying that those continue to apply. So if the EU had agreed, for example, a trade agreement with Australia during the course of the transition period, that trade agreement would not have automatically extended to the UK. Can I have the next slide, please? The Withdrawal Agreement Act also gives domestic legal effect to the withdrawal agreement. The withdrawal agreement contains commitments on the part of the UK extending beyond the transition or implementation period. For example, as David mentioned, the Court of Justice continuing to have jurisdiction to hear cases for up to 8 years after the end of that period, and also certain rights given by the withdrawal agreement last for the lifetime of anyone who's accrued them. So Article 4 of the withdrawal agreement required the UK to ensure directly applicable provisions of that agreement were given the same legal effects in UK law as they would have in law for states, and enabled legal or natural persons to be able to rely on those provisions. And UK would require compliance with those commitments. And it's the Withdrawal Agreement Act which gives effect to those, firstly by inserting into EUA a new Section 7A. We can almost think of this as an equivalent provision to Section 2.1 and 2.4 of the European Communities Act 1972, giving supremacy and direct effect to the provisions of the withdrawal agreement, much as the EU treaties were granted that during the UK's EU membership. So the Withdrawal Agreement Act provided for dynamic tracking of the withdrawal agreement. So if the withdrawal agreement was changed, then the direct effect of those rights were also tracked. And of course, this is particular importance if you remember that the withdrawal agreement included the protocol on Northern Ireland and Ireland, which provides for the Northern Ireland's unique position within the UK and the EU. So we have this rolling, if you like, stretched out or extended withdrawal position for Northern Ireland. And just to mention in passing that just as a new Section 7A was inserted into EUA to deal with the EU situation, there's similar provisions inserted in respect of the EEA, EFTA and Swiss. Next slide, please. In terms of the citizens' rights provided under the withdrawal agreement, these actually didn't really change between the Johnson deal from Theresa May's deal. The withdrawal agreement continued to provide a framework for legal residence and rights of EU citizens living in the UK and UK nationals living in the EU at the end of the transition period, referred to as a protected cohort. And the Withdrawal Agreement Act delivered these commitments domestically using regulation making powers, including the famous Henry VIII powers, for covering matters like entry and residence, deportation, rights of appeal, social security coordination, etc., as I've listed them there, and the establishment of an independent monitoring authority to ensure that the UK had implemented the citizens' rights parts properly. And the Withdrawal Agreement Act also provides that UK courts can refer questions on citizens' rights to the Court of Justice for 8 years following the end of that transition period. Next slide, please. I'll just briefly touch on devolution given time. As I said, the Withdrawal Agreement effectively, the Withdrawal Agreement Act changes the devolution statutes and EULA to reflect the transition period and to give the powers to the devolved administrations in order to allow them to make changes necessary consequent on that. I think given time, I'll just move on because I need to cover the trade and cooperation agreement. So can I have the next slide, please? So the trade and cooperation agreement is the third significant international agreement, 24th of December 2020, and setting out the EU-UK future relationship. I've called it the TCA Plus on the slide there because it's not just about trade and cooperation. It's called the TCA, and the trip's by far the longest in the text. But the cooperation element covers law enforcement and government's arrangements. But there's also an agreement on nuclear cooperation and an agreement on security procedures, which supplements the trade and cooperation agreement. And there are also financial, unilateral decisions to be taken by both sides in terms of equivalence decisions. Particularly, I think people are quite aware of the data adequacy equivalence decision, which seems to be going the right way, but isn't quite over the line yet. But the withdrawal agreement's not superseded entirely, but and also member states' benefits UK used to enjoy not incorporated into the TCA, so things like free movement, obviously no longer available. I was going to talk about the structure of the TCA, but I think I'll just skip over that. Perhaps just sharing one. So the trade section of the TCA, to take one example of how the TCA provides for a form of prior EU law to be recreated under the Trade and Cooperation Agreement and then given domestic effect through EUFRA, the Future Relationship Act. The level playing field provisions of the Trade Cooperation Agreement effectively recreate the old EU law idea of state aid. Many of the concepts are the same, they've just been renamed. So what used to be an undertaking becomes an economic, subsidies are what used to be state aid. Many of the principles and principles are the same. So if I can have the next slide, please. So the EU Future Relationship Act 2020 passed, whizzed through Parliament at the end of December 2020, gives domestic effect to the TCA. And it does this in a number of different ways. Some elements, for example, security, are dealt with through substantive legislative provisions. Other elements like customs and tax are dealt with through modifications to existing domestic legislation. one thing which I hadn't seen before is that EUFRA modifies some of those onshore EU regulations, which, for example, EC regulation on access to the international road haulage market. EUFRA substitutes a form of license in that EU regulation, now onshored, for a different form of license set out in the TCA. And there's also some implementational terms provided you can make regulations to implement the TCA. But most importantly, I think, is EUFRA section 29, which is another general conduit which provides that existing UK law has to be modifications, and this is the text now, as are required for the purposes of implementing the TCA, so far as the agreement concerned is not otherwise so implemented, brackets in domestic law, and so far as that implementation is necessary for the purposes of complying with the international obligations of the UK under the agreement. So this means that where necessary to give effect to the Trade and Cooperation Agreement, Section 29 incorporates the content of the TCA directly into domestic law and gives it direct effect as part of that domestic law. So existing domestic law has been modified by the TCA through Section 29 insofar as necessary to give effect to the obligations in the TCA. And there's actually an application of this in a recent case of Lipton and the City Flyer, where Lord Justice Coulson goes through the process of applying Section 29, looking at whether the domestic law has been modified or if it's already consistent, and then to look at what modifications are necessary in order to comply with the UK's obligations. And he also looks at how the principles of interpretation to be applied under Section 30 of EUFRA, which relate back to the interpretation provisions in the Trade and Cooperation Agreement. So there is no time limit on the operation of the provision. So in theory, it could operate for the foreseeable future, much like the European Communities Act did, as a conduit by which the Trade and Cooperation Agreements given domestic application. But I think it's more likely that the situation will be temporary, because as subsections 1 and 2 provide, the application of 29.1 is subject to specific legislation being made which purports to implement the TCA. So it's the government's current legislative program has a number of bills in it which are attempting to establish a new sort of ground zero for in particular areas. So I think it more likely that while there may be gaps, I think the government will be attempting to say, you don't need to go back to the TCA all the time because we've got this new domestic law that implements the obligations in the TCA, and so you don't need to go back and use the Section 29 route to plug the holes. Finally, I just mentioned that the fact that Section 29 exists achieves one of the obligations, fulfills one of the obligations under the TCA, i.e. to provide for that. So next slide, please. If I can just very quickly summarize. Basically, the 1972 Act was repealed through EUA, but we have a number of new conduit pipes replacing that old single large conduit pipe, if you like. So first of all, we've got EUA, retained EU law being onshored and converted into domestic law. That then has the gloss put over it of, mixing metaphors, of the Withdrawal Agreement Act as regards the implementation and transition period. We then have the Withdrawal Agreement Act giving effect to substantive provisions, including the Northern Ireland Protocol and citizens' rights. And then finally, we've got the Trade and Cooperation Agreement, it's self-containing substantive provisions, some of which may have been given domestic effect through standalone legislation, but with the backstop, if you like, of Section 29 of EUFRA, providing that the TCA itself can, in certain circumstances, have domestic effect. So that hopefully is a helpful summary of what retained EU law, what EU law post-Brexit comprises. And with that, I'll finish and I'll pass back to David. Thanks.
Aaron, thank you. Thank you, everybody, for listening. There's quite a lot there, as I think we all appreciate. But I hope that last slide, the sort of the takeaways, are important ones to have in one's mind. Again, this concept really that what is retained is in effect the old legislation that was given effect to by our membership of the Union over 45 years. It's not been repealed or got rid of, it's been captured, and there are various tools in relation to how you interpret it and how it has effect going forward. That's an important component of what the new regime is all about, and as Aaron's explained, really sort of modified and amplified by the other legislation that gives effect, in particular, with particular importance, I think, to the Trade and Cooperation Agreement via that important Section 29. So there's quite a lot there, and we hope you found this talk a useful introduction to it. I've not noticed any particular questions coming through on the Q&A, but if anybody has any, if they like to either raise it now or indeed drop either Aaron or I an email, we'd be delighted to come back to you on it. I've got no questions coming through. And so if that's right, please don't hesitate to drop us a line if there's something that you would like to explore with us, and we will draw it to a close there, bearing in mind that we're now past midday. But many thanks indeed for your interest in the first place and your attendance. There are a series of these coming up, all on different topics. And we hope to see you again shortly on that regard. So thank you very much.